Welcome everyone to our Community Care, Adults and Children in Education Law, a Year in Review webinar. Thank you for joining. I have a few housekeeping matters to go over at the outset. So the event is being live streamed and recorded. The recording will be uploaded to our YouTube channel with the link, and slides will be sent to all of you. If you have any questions, please put those in the Q&A box and our speakers will aim to answer your questions at the end of the webinar, time permitting. We're aiming to finish at 7. And this free webinar is brought to you by the Garden Court Chambers Community Care and Education Law teams. So what will we be covering this evening? Our speakers will bring attendees up to speed on key case law and legal developments over the last 12 months. We will first be hearing from Bethan Harris and Ricca-Richardson on adults' health and social care, and they will present on key developments spanning the CARE Act 2014, asylum support, continuing healthcare, and Section 117 aftercare. We will then be hearing from me, Nicola Braganza and Ollie Persey, presenting on key developments spanning support for unaccompanied asylum-seeking children and disabled children under the Children Act 1989 and the Chronically Sick and Disabled Persons Act 1970. And then finally, Buttle and Alex Temple will be speaking about special educational needs and school exclusions, presenting on key developments spanning the duty to secure special educational provision, the application of the protection duty in school exclusions, and key recent case law from the upper tribunal. I'm just going to very briefly tell you something about all of our speakers. So starting with myself, I specialize in equality and discrimination law, public law and human rights, and my practice spans education, community care, immigration detention, immigration asylum, and employment discrimination claims. Bethan specializes in community care law and social housing. She jointly convenes the community care and education team at Garden Court and is a founding member of the recently started Community Care Lawyers Group, which was launched in November 24. Ollie has a broad public law practice focusing on the rights of children, asylum seekers, migrants, and disabled people. He is ranked in Chambers and Partners and the Legal 500 across his core practice areas, and his community care practice spans age assessments, asylum support, welfare benefits, and health and social care. And Ollie also co-convenes Garden Court's education law and community care teams. Isaac practices in judicial review, immigration and asylum, human rights and civil liberties, education and community care. Isaac is regularly instructed in challenges to age assessments on behalf of unaccompanied asylum-seeking children and in matters involving the entitlement of children and adults to support under the Immigration Asylum Act 1999, Children Act 1989, and Care Act 2014. Alex specializes in public law, discrimination, and human rights, with extensive experience in education, community care, policing, and criminal records. Alex advises children and vulnerable adults in cases arising from schools, colleges, exam boards, universities, integrated care boards, and government. He's written papers on impacts of criminal exploitation on children facing school exclusion, alternative provision on children's educational potential, and potentially discriminatory effect of school disciplinary measures. And Abby is building a broad human rights, public law, and civil liberties practice, specializing in immigration, education, and community care. Abby has successfully represented parents and children before the first-tier tribunal SEND in EHCP appeals and throughout the school exclusion process. And Abby has worked on constitutional cases concerning the right to education at the Legal Resources Centre in South Africa. So you're going to be hearing from a lot of people across a lot of areas on a number of key cases. And we're going to kick off with Isaac. So over to you, Isaac. Thank you very much.
So for my part of this seminar, I'm going to address you on 3 adult community care cases, as well as looking briefly ahead to a judgment that we're expecting in the coming months. Those 3 cases are Campbell, which is about the interplay between Housing Act and Care Act duties, TMX, which is mostly about the interplay between asylum support and the Care Act, and DXK, which is primarily about the Home Office's profound failure to monitor its accommodation provision. So to begin with Campbell, This was a case involving a man with significantly impaired vision, OCD, and depression, who had care needs that were accepted by both parties. The local authority had been providing him with temporary accommodation since 2016, ostensibly under the power to provide interim support in Section 19 of the Care Act. However, after a period in which his social worker had been helping him to apply for social housing, and he had allegedly rejected several properties as unsuitable, the local authority decided to stop funding his accommodation and asserted that it had no duty to do so under the Care Act. And the facts are at paragraphs 4 to 15 of the judgment. So the key issue in the case was whether the local authority had to provide the claimant with housing as part of its Care Act duties, or whether it was excused from doing so by Section 23 of that Act. Which provides that a local authority may not meet needs by doing anything which it or another local authority is required to do under the Housing Act. So the claimant had argued that in a case where he had accommodation-related needs, which means a need for care and support which could not be effectively delivered without accommodation, and that definition of accommodation-related needs is from the case of Aburas, which is on the screen there. And he had argued that in circumstances where he did have accommodation-related needs, the refusal to house him under the Care Act was in breach of that Act. And that submission was rejected by both the High Court and the Court of Appeal, the latter of whom held that where a local authority is, quote, required to offer housing or to, quote, make provision for homelessness under Part 6 or 7 of the Housing Act respectively, Section 23 means that the local authority cannot be required to provide ordinary accommodation under the Care Act. And that's the paragraph on the screen now. So that passage in itself is not hugely helpful as to what Section 23 means, because the use of the phrases required to offer and required to make provision are, to be frank, quite vague. When you read the judgment as a whole, what it means is that in any case where a person is in principle eligible for housing under either part of the Housing Act, there is no power or duty to provide ordinary accommodation under the Care Act. So therefore, it's not even necessary for the local authority to have made an actual offer of accommodation under the Housing Act before Section 23 comes into play to disengage the Care Act duties. That's what the claimant had suggested, and it was rejected by the court. And that quite broad interpretation of Section 23, which the court adopted, can be identified from two things. The first is the court's approval of the earlier decision of Adolo, where the applicant had actually been on the highest priority band for social housing for some time, but had not yet been given a new house, and the court held that Section 23 was engaged. And the second indicator of that interpretation is the judgment of Lord Justice Males in Campbell. It's a concurring judgment, and that clearly focuses on the importance of giving priority to an authority's housing prioritisation scheme, and not on whether the person has actually received an offer of accommodation. There are also three other points from this judgment that it's worth flagging to you. The first is that the Court of Appeal confirmed that this principle relating to Section 23 is not confined to cases where the applicant is already in council accommodation. So that means it also bites where the applicant does not have council housing yet. The second is that the principle might not apply where a person requires specialist accommodation rather than ordinary accommodation under the Care Act. The defendant conceded that at paragraph 55 of the judgment, and what paragraph 63, the key paragraph I took you to, refers to is ordinary accommodation under the Care Act. And the third point is that the principle also does not apply in cases where the person is excluded from the Housing Act, for example, because they are subject to immigration control. In those cases, there may be a duty to provide accommodation where a person has accommodation-related needs. So the second case I want to talk about is TMX. So this is a very, very long judgment, and it deals with a situation where an asylum seeker was in woefully inadequate accommodation that breached his human rights. But there are just two things that I want to raise about it today. So the first one is that TMX provided the last word in a long-running dispute between local authorities and the Home Office as to who is required to provide accommodation to disabled asylum seekers who have accommodation-related needs. The short answer to that question is that in assessing whether a person has accommodation-related needs, a local authority is required to disregard any current or potential provision of accommodation under Section 95. The reason for that being that the legislation makes clear that Section 95 is intended to be a residual safety net, meaning it should only catch those people who have been unable to benefit from any other legislative scheme. So if the Care Act's in play, that comes first, basically. And if the result of that, of an assessment as to whether someone has accommodation-related needs, is that they do, it is then the local authority, not the Home Office, that is required to meet them. That's clear from paragraph 92 of TMX. And the purpose of that is partly to avoid what the judge called a perverse game of endurance, where you wait and see whether the Home Office or local authority blinks first and accommodates. Meanwhile, the individual is left without housing or suitable housing. The second key point from this case is that TMX also gave helpful guidance on the content of the duty to meet accommodation-related needs. So in short, the duty is not just to provide any accommodation, but to provide suitable accommodation. Now, what suitable means is accommodation that, in the words of the judge, enables the person's care needs to be met. So suitability, in my interpretation of the judgment, is inextricably linked to the individual's health conditions, to their physical challenges, and to their associated care needs. And to illustrate that point, in TMX, the accommodation was unsuitable because it had only one bedroom, because the claimant, who was profoundly disabled, could not access the bathroom at all, he could not use the shower, and he could not access his accommodation via his wheelchair. So the suitability, the reason it was unsuitable, was inextricably linked to the needs that he had and his disabilities. And there is also a further indication, I can't really put it any higher than that, but an indication in TMX at paragraph 26 that the suitability of accommodation can, in principle, take account of an individual's family situation, in particular when they are in receipt of intimate care from family members. So in this case, it was held that it would not be reasonable to expect him to live otherwise than with his family. The final of my three cases is DXK. This was a challenge against delays in the Home Office moving pregnant and new mother asylum seekers from initial accommodation, so hotels and places like that, to dispersal accommodation, which in this case meant longer term self-contained housing with kitchens and private rooms and so on. And there are two things that I want to focus on in this case. The first is about systemic challenges to the provision of Home Office accommodation. And the second is about the public sector equality duty, what I'll refer to from now on as the PSED. So one of the core claims in this case was that the Home Office's policy and practice for providing asylum accommodation to this cohort was systemically unlawful because of the extent of the delays in providing dispersal housing. So that challenge was brought both on domestic grounds, namely that there was a systemic breach of the duty under the 1999 Act to provide adequate accommodation, and it was also brought on the basis that the system was in breach of Article 3 of the ECHR. And the discussion of those respective grounds is at paragraphs 93 to 112 of the judgment. In terms of the domestic challenge, first of all, that was decided against the criteria in the A case, meaning that the claimants had to show either that written guidance positively authorised unlawful conduct or that the system inevitably gives rise to unlawfulness in a material number of cases. The court found that there were several factors for which the Home Office could be blamed that increased the risk of delays, including the lack of any internal deadlines for issuing accommodation requests and limited enforcement against private contractors. So that's helpful insofar, well, for claimant-led practitioners, insofar as this is the next in a long line of cases, another one being called DMA, which found that there are systemic issues in the provision of accommodation. Unfortunately, again, for claimant practitioners, the court refused to make a declaration of systemic unlawfulness on those domestic grounds on the basis that DXK's own claim was academic and that there was an insufficient pool of evidence of unlawfulness in a sufficient number of cases to make the finding. So what that means is that if you are bringing a case such as this, you want to ensure that you have a pool of evidence looking beyond just your own client in order to make good a finding. As to the human rights systemic unlawfulness ground, the test that the court applied was whether, looking across the full run of cases that go through the system, it creates a real risk of a breach of a fundamental right. So in this case, the court again rejected this ground because the claimant lacked sufficient interest to bring it, which meant that she was no longer a victim because she had actually been transferred to dispersal accommodation already. Ollie's shaking his head at that, which I can agree with. That was effectively a way of the court getting around having to make a substantive decision on this matter. But what is useful about the judgment is that test that I've just referred you to at paragraph 84 of whether the system creates a real risk of breaches. That's a pretty neat encapsulation of that test, I would say more clearly set out than it has been previously, and it's a crucial test to know for any practitioners that are dealing with a systemic challenge on human rights grounds. The second thing to focus on from this case is the PSED ground. Unlike the others, this was granted because of the Home Office's unlawful failure to collate and monitor statistical data on the numbers of people in this group, the timescales for dispersal requests, and the timescales in which dispersal accommodation was in fact provided. That's paragraph 152 to 154. And there are 2 points of general importance about the PSED, which show that it can be a good way of holding public authorities to account. So the first one is not new to this case, but was stated quite clearly, which is that the duty under the PSED is likely to be more strongly enforced than the ordinary Thameside duty of inquiry. The test that the court will apply is still rationality, but the intensity of that review will depend on the context, which obviously for the PSED includes potential discrimination. And the quote from the judgment is in the second bullet point there. And then the second point is that DXK reiterated the importance of statistical monitoring. So the court didn't go as far as to hold that monitoring will always be required to comply with the PSED, but they did indicate that it is more likely to be required where there are many vulnerable people in a system and where certain protected groups are likely to be disproportionately affected. Applying that to the facts of the case, in DXK, the Home Office had argued that its failure to monitor was not unlawful because there was no risk of street homelessness. And they compared it with a case called DMA where there was a risk of street homelessness and said that that's why you don't need to monitor here. The court rejected that and held that there was a, quote, particularly weighty PSED duty in this context because of the very grave potential impacts on this group of people, because there was evidence of risks to maternal health of being in this initial accommodation and to the physical and mental health of young children as well. So what we can take from that is that any PSED challenge you do bring, especially if it's based on monitoring, will want to identify why your cohort is especially vulnerable and what negative impacts the policy in question could have on them, which may need to be monitored. So those are the 3 cases I wanted to address you on. I hope it's been useful. The very last thing I wanted to say is just that some of the issues that have been raised by TMX and DXK were recently ventilated before the High Court in a case that I was working on, for which we are awaiting judgment now. There's a very strict anonymity order in place, so I'm not going to say too much, but I can say that the case is considering as one of its core issues whether the TMX principle about disregarding Section 95 when assessing accommodation-related needs also applies where the applicant is in receipt of Schedule 10 accommodation. So that means migrants who are not asylum seekers or failed asylum seekers, but who would be destitute without support. And in addition, one of the grounds of challenge in that case that we're awaiting judgment on is again that the Secretary of State's system for providing accommodation, this time to what we framed as complex cases, is unlawful because it creates a real risk of breaches of Article 3 of the European Convention. So look out for that judgment in the coming weeks and months, as we may have something else to base our learning on in this area. Thank you very much. I don't have anything else to say.
Thank you very much, Isaac. Bethan.
Thank you very much. Thank you. I'm going to continue on the subject of adult social care until just after 6 o'clock, so just for about the next 10 minutes. And I'm going to talk, first of all, about charging, then briefly about a case relating to a health package in the community, and then finally, if there's time, some highlights from policy and legislation over the last 12 months. So first of all, on this slide, charging for care and support services under the Care Act, and two issues which have come up in recent case law. First of all, in March of this year, the case of March of 2024, the case of YVR against Birmingham City Council. And this concerns the protection that there is for earned income when it comes to the means testing for calculating the charge for services provided in adult social care under the Care Act. And the position then in this case briefly was that this was an Article 14 and Protocol 1, Article 1 challenge and public sector equality duty challenge to the calculation of the charges for YVR. And it was brought on the basis of arguing that the protection of earnings, which are exempted essentially from being part of what's taken into account in the means test, that exemption, when calculating the charge, discriminates against people who do not have earnings because they can't work because of disability. The court dismissed both grounds, holding that this was a Flimenos challenge and that the council's aim of balancing its budget, given its financial situation, it has effectively declared itself bankrupt. It was that bad. Made its position not manifestly without reasonable foundation. And this is a case which is being appealed to the Court of Appeal. So obviously that claim was unsuccessful. It came in the footsteps of an earlier claim which was successful on the same point, but with different facts, in which the aspect of the dire financial straits of the local authority was not so much at the fore as it was in the Birmingham case. And that's the Norfolk case, which was back in 2020, when SH brought a claim which raised the same point. She was is a person who has Down syndrome and a learning disability and is unable to work, so has no earned income. And the amount of her income that was taken into account in order to be assessed for the means test was disproportionate when compared to the amount of income that would be taken into account of a person who had earned income, because earned income is protected. And I ought to have mentioned that this is the scheme under the Care and Support Charging and Assessment of Resources Regulations 2014, which are part and parcel of the Care Act regime. That claim was successful. So we will see in due course what the outcome is of the appeal in the case of YVR and how the land will lie in this area after the decision of the Court of Appeal in that case. So staying with charging to the second area, which is very much linked in terms of what it's about in relation to charging, the disability related expenses heading, which is, again, this is a type of expenditure which is protected from the means test. So where a person uses their income in order to meet disability related expenses, then that income should not be taken into account in the means test, which calculates the charge for their care and support services. And the issue that arises, therefore, is what is the scope of disability-related expenditure? And the case, the Maidenhead case, I've included because it's very useful in identifying that scope very clearly. It's a helpful decision. It's a relatively broad parameters attributed to the concept of disability-related expenses. So that's an important decision in this area. And then a useful decision by the Local Government and Social Care Ombudsman at the end of 2023, the refusal of the local authority in that instance to allow the professional deputy costs of the complainant to be allocated as DRE was wrong. A person lacking mental capacity for whom a deputy has been appointed by the Court of Protection in their best interests. That is requires their costs to be paid, and those costs we know should be identified as DRE and therefore not taking into account in the means test. So that's a useful decision from the Ombudsman. Thank you. Okay, so now I'd like to go to a case to do with an NHS continuing healthcare package in the community. And the facts of this case very briefly were that this was a very large package. It's a health package as opposed to a social care package under the Care Act. And it involved the claimant who had a complex condition, and in fact a number of conditions requiring many appointments and different procedures and equipment, and care staff with a lot of administration attached to it. And she had in fact taken some additional premises in order to add some extra space on to her 1-bedroom flat in order to assist with the administration side of keeping her care package, which was run on a personal health budget or direct payment in this instance, to keep it up and running. And one of the issues in the case was whether the cost of the rent for that additional set of premises could be covered within the care package. And there were also a number of other headings in relation to the costs that had been allocated in the care package and their sufficiency. So this was a case which was ultimately unsuccessful, but it was obviously a very hard fought case. It was a case which was commenced on issued on a protective basis because of being up against the time limit. And after issue, during a period of a stay, the original decision was reviewed by the ICB, and it was the reviewed decision which then became the subject of the challenge. So it may be that there was some progress made in that period of a stay, and it's quite interesting to just note that procedural aspect of this particular case. But this is a very useful case for all practitioners. And in my remaining 2 minutes, I'd just like to highlight a few of the points that are in it. First of all, it will tell you where everything is in the law in relation to these types of packages, and it will tell you where to look in relation to direct payments, and also some of the sort of facets of the direct payment regime in relation to health as opposed to social care. So it's useful on that footing. I won't go into any of the detail of that. It's all on the slide. There's a very useful paragraph 15 in the judgment, and this is the judgment of Mr. Justice Fordham, and it's characteristically a very clear judgment. And he sets out the relevant public law principles applicable in this case, and of course will be helpful in other cases with similar subject matter. And it's so useful to read a setting out of principles which we know, or we think we know, we should know, but it's so useful to see them set out clearly and a reminder of them, and of the nature of the decisions in this sort of case that are made by public bodies are evaluative judgments. And obviously that very much colours the way that they're regarded in terms of application of public law principles. The paragraph 15 sets out the principles for the conventional standards of reasonableness review, usefully also the approach to interpreting documents, including assessments and care plans, and then something about the intensity of review. The intensity of review is high in this sort of case. So those are extremely useful points to always have in mind. And then just a couple of final points on this case. I've mentioned it was issued protectively. I think the final point perhaps is just the sheer amount of work that was clearly involved in marshalling the facts of the case. If you read the case, you will just see how fact heavy it is. And that is, of course, quite typical of the cases that we do. It's not just the very complex care packages, it's every care package really requires all that really hard work in just really going through the facts, and every little detail matters. when trying to sort of get to the bottom of where the point of law lies. I've highlighted some of the developments in policy and legislation and some statutory guidance on discharge to assess, the new model for discharge from hospital. And that's everything for me. Thank you.
Thanks very much, Bethan. So Ollie and I are going to deal with the next section on children cases in community care. So I'm going to start by telling you about 3 particular cases. A, which concerned a healthcare plan and the duties that were owed in respect of providing one. AYW, which sets out the principles on when a mandatory order is made. And then DF, which looked at the issue as to whether DF was to be treated as a former relevant child. And then Ollie will speak to TWODNTS and also the Law Commission's consultation. So the facts in A concerned the claimant, who was a severely disabled 11-year-old boy with complex health needs. He had has a rare SLC 13A5 citrate transporter disorder. The effect of that was life-threatening and life-limiting. As a result, he suffers from severe epilepsy, which places him at risk of sudden death in epilepsy, episodes of atonia, placing him at risk of suffocation, a severe learning disability, and communication and mobility disabilities. He was in receipt of a continuing care package from June 2015, and that after all sorts of very serious problems and difficulties in carrying that out, was brought to an end on the 9th of July by the provider Enviva. The day after it was brought to an end, and this is now set out within the judgment at paragraph 41, on the 10th of July, a nurse and carer from Nursing Direct arrived at the family home. In her first statement, the mother avers the staff from Nursing Direct were not aware of A's name. They had not been provided with Enviva's care plan. They knew nothing of A's care needs. The mother further contends that this was in the context of Nursing Direct having not liaised with Enviva. On the 11th, the following day, the mother notified the defendant that the family would be privately contracting with Enviva and PS to maintain A's care package, and that Nursing Direct should stop attending their house. They instructed Nursing Direct to stop sending staff until further notice, and the upshot of that was that the parents were then responsible for funding the care package at a cost of £10,000 per week. So the claimant had an education, health and care plan in place that had been issued back in November 23. Section C of the EHCP detailed his health needs and the nature and extent of his condition. E detailed the desired outcomes, and then G specified what the health provision was that he required, and that included ongoing review, monitoring and assessment from his multidisciplinary team, yearly blood tests to monitor the impact of anti-epileptic medications on his liver, biannual review of orthotics, provision of equipment, 2 people to manage his seizures, an urgent care plan, and the provision of medication. And the section G set out, the claimant will be provided with a healthcare plan. The challenge was brought on the basis of 3 grounds. The first was that the defendant was acting in ongoing breach of its duty to ensure that the claimant had a lawful healthcare plan, which was successful, accepted and succeeded. 2 and 3 were dismissed. The second ground was that the decision to terminate the then current registered care provider's contract on the 9th, replaced with the new care provider on the 10th, was irrational. And the third was in respect of the funding package, the cost of £10,000 a week. And as that had arisen from D failing to arrange lawful healthcare for claimant, for that reason, the claimant's family said that they were entitled to restitution on the ground of unjust enrichment. So as I set out, ground 1 was successful, and the court made a mandatory order for the defendant to produce a healthcare plan. The other 2 grounds were dismissed. The judge's reasoning, so the judge's reasoning focused on specifically section 42(3) of the Children and Families Act, which is very clear in setting out if the plan specifies healthcare provision, the responsible commissioning body must arrange the specified healthcare provision for the child or young person. And so the court, and I think it was Mr. Justice Lavender, set out that by ground one, the claimant contends the defendant is ongoing breach of its duty to ensure that the claimant has a lawful healthcare plan. And the court went on to say that the claimant contended, pursuant to section 42(3), the defendant is under an absolute and non-delegable duty. The term arrange has not been the subject of judicial consideration. There's no authority on the interpretation of the term arrange. However, adopting a purposive interpretation, the duty to arrange the specified healthcare provision must, in my judgment, encompass the defendant satisfying itself that the specified healthcare provision it is under a duty to arrange has in fact been put in place, and to take further reasonable steps to arrange it if it has not been. So on that basis, ground one was successful. In respect of grounds 2 and irrationality, the court found that the high threshold for irrationality had not been met. And 3 is now in the Court of Appeal. I don't know whether there's a date set for it. I'm looking at Ollie. No date. Ollie is in it, as well as this one and the next one. So on the restitution point, the court held that it was determined solely on the basis that it was the parents rather than the claimant who paid for his care, and therefore, if the defendant had benefited, it was not at the claimant's expense for the purposes of the legal test for restitution. And so, as I say, permission to appeal has been granted. AYW. So this was a case concerning mother and son. C1, mother, an asylum seeker from Mexico. C2, her son, a severely disabled 5-year-old boy experiencing frequent seizures in the region of 7 to 10 times a day, fed by a PGJ feeding tube. Mother cared for son who required close supervision, full adult support for transfers. They lived in a hotel room in Southwark, provided by the defendant pursuant to duties under section 95-96 of the Immigration Asylum Act, 99. Further evidence and illustration of how complex the boy's needs are was that in summer 21, for 3 months, he was admitted to King's College Hospital, remained under the care of specialist teams, and under the care specifically of a number of specialists. I've set them all out there. And what he needed, and his mother, what they needed was accommodation that was wheelchair accessible and with a wet room. And in the absence of a working, reliable lift, his accommodation would need to be on the ground floor. The council had granted expedited dispersal within 3 miles of the current accommodation, dating back to December 23, which featured heavily because on that basis, the court accepted and set out that meant that the defendant accepted that their accommodation was not adequate and that alternative accommodation was required urgently. So it followed that for a period of a year, they'd been on notice of this. One ground was advanced and it was conceded that there was a breach of the duty. So the focus was on relief, what should be granted. And there was evidence from the council as to their not being the accommodation available. There was evidence from the claimant saying actually on inquiries there was accommodation, various accommodation available, and the judge, who I think was Tom Little KC, sitting as a Deputy High Court judge. Yes, is that right, Ollie? I think so. Yes. So the judge referred to the principles that are set out by Lord Sales in Imam. And importantly, this is the first time that the principles have been considered in detail by the High Court in the context of asylum accommodation. And the court found that the searches of the claimant's solicitors for potentially suitable properties on the private rental market substantially undermined the defendant's poorly evidenced assertion that procuring such property would be impossible. The point that comes out in the judgment was that there wasn't even evidence about efforts having been made to find alternative accommodation. It was just the assertion that there wasn't any available. The inadequacies of the SSHG's chosen subcontractors, including their lack of appropriately adapted housing, was not a reason to make an order. And significantly, the court clarified what was meant by resources in imam, noting that in the asylum accommodation context, it is important not to align resources in the sense of financial resources with resources in the sense of housing stock that CRH avails itself of. I add, there's no evidence before me from anyone to support the impossibility submission. Right, so that is AYW. One other slide on this, where the court set out, and this is important because reliance was placed on the defendant's wider failings. The court noted this claim is not an isolated incident or an outlier. Examples of authorities were NS and DXK, which you've just heard about from Isaac. If there's systemic shortcomings in the defendant complying under section 95 and 96, that is a reason to make a mandatory order, providing it is not impossible to comply with its terms. And so the court made the order. The court then debated how much time should be given for the order to be complied with and the level of detail within the order as to its geographical range, and gave the defendant until, I think, the end of February to come up with accommodation. So DF, this is the final of the three that I'm dealing with. This was a case that came before the Court of Appeal, and the Court of Appeal described it as a sad case and set out the facts, which were that the appellant, a young woman born in 2005, had a chaotic childhood. Her parents separated when she was young. Her mother had numerous problems. For a time, she lived with her father. After difficulties with him, she moved back to live with her mother. They lived together in a council flat, and later that year, her boyfriend moved in with them. They were joined by her mother's fiance. The tenancy was managed on behalf of the landlord by Colchester Borough Council. And then next slide, please. Very sadly, her mother then died. So in August 22, her mother died unexpectedly. And at that point, she was 8.5 months short of her 18th birthday. She had no parental supervision. She had some support from family and friends. She was the only adult in the flat. The only adult was her mother's fiance, but he moved out in November. She wasn't in education, employment, or training. She had no regular income. She had some social work support. Following her mother's death, a senior social worker was appointed. An assessment, Section 17 assessment was performed, and some forms of support were offered. And in respect to the tenancy, it expired on the 2nd of January, but after the 2nd, the council did not immediately proceed to take eviction proceedings. They decided to grant her a tenancy of suitable alternative accommodation and take no steps to evict her in the interim. And just over a week after her 18th birthday, she accepted an offer on another flat. Prior to the offer, Quorum set out in a pre-action protocol letter that the failure to accommodate her, provide her with services, was contrary to statutory duties under section 17 and 20. And the council replied saying, well, there was no need for her to leave her home yet. And so the claim was, should she be treated as a former relevant child? And what was said is, between the expiry of the notice to quit and her 18th birthday, she required accommodation under section 20, and it should have been provided. If she'd been provided with that accommodation, she would have been a looked after child, and so post 18 qualified as a former relevant child. And although the council didn't in fact provide her with accommodation, it had a discretion which she says it should have exercised in her case. The focus was on whether the phrase requires accommodation in section 20, where that's a matter of law to be construed in the same way as the definition of homelessness in section 175 of the 1996 Act. And alternatively, if it didn't apply, the council was wrong to conclude that she didn't require accommodation. And the Court of Appeal said no, very different subject matters, different statutes. And so whilst there is some connection, the claim was, well, the appeal was dismissed and the judgment of the lower court upheld. The Court of Appeal saying, and this was Lord Justice Underhill, that section 2175 are provisions of different statutes, different subject matters. One is in respect of the welfare of children, the other homelessness. There's no indication the provisions are intended to form part of a single statutory scheme. And while both could be said that they should in one sense march hand in hand, that is only in the sense in a given case either duty might in principle be engaged. And so on that basis, unfortunately, the appeal failed. And those are the three I'm dealing with. I'll now hand over to Ollie.
Thank you very much, Nicola. I'm going to pick up on a case about former relevant children status and go very briefly through it. So people who practice in this area will be familiar of coming across young people, a little over 18, who were denied Section 20 accommodation because when they were in a vulnerable position, they were not given all the information to make an informed choice between Section 20 accommodation and Housing Act accommodation. And I think there are some gems in this case, despite it failing, which you can use, and I have used in cases to successfully get a young person treated as a former relevant child, and the sort of panoply of support that comes from that. So I'm not going to go through the facts in detail. And this is essentially setting out what the challenge was. Again, the focus was the decision that he was not a former relevant child. It was challenging the Essex Nest system of sort of essentially diverting from Section 20 was the allegation for vulnerable teenagers into Housing Act accommodation. And then subsequently, they would not accrue the 13 weeks to become a former relevant child and get access to the care leaving support that you get as a former relevant child. The challenge was, in this case, should the local authority be exercising its GE Eritrea discretion, which you saw about on an earlier slide. The claim did fail, but I want to direct you to these helpful points. So it's paragraphs 97 and 99 that I particularly want to draw your attention to, which emphasize the role of the national guidance that's in place and the need to properly inform a child about their options. On the evidence here, the local authority got over the line. However, it is clear that the child has to be properly informed and has been reached after their decision has been reached after careful consideration of all the relevant information. And notably, it said user-friendly format. It has to think about the capacity and agency of the child in making that decision. This is the point that I've found helpful in pre-action correspondence and grounds to get local authorities to concede this point where they do have sharp practices or don't have good record keeping in respect of how much information that they provided to a child in this situation. So paragraph 99, I think, is gold dust for practitioners, despite the case overall being a disappointing outcome. It is at least, very least arguable, so tick permission, in the light of the above, that the defendant could not claim to have done, in accordance with Section 26 of the 1989 Act, what was reasonably practicable and consistent with the child's welfare to ascertain his wishes and feelings regarding the provision of accommodation. It was fact-specific why it failed here, but bad explanation potentially gets you into the GE Eritrea discretion because the child was not fully informed about their options and therefore was essentially unlawfully gate-kept out of Section 20 accommodation and denied their statutory rights as a looked after child. So I'm briefly going through two cases. Those of you with good memories will recognise this case from last year's update, but there was a part 2 to it, which is the interesting point I want to draw your attention to. So briefly, ODN had complex needs, brought a claim for judicial review, asserting that Merton had failed to provide adequate care and support to meet her needs under Section 17 of the Children Act 1989 and Section 2 of the Chronically Sick and Disabled Persons Act 1970. So far, so conventional a claim. The standard children's social care provisions. The application of interim relief grant was granted in part. There was a serious issue to be tried. We're familiar with that test. Merton's analysis of the claimant's needs had not engaged with ODN's points, and there was no reasoned basis for its conclusion that AA needed to know further help pending a full assessment. There was also a serious issue as to the rationality of Merton's reliance on the availability of respite care in the absence of any reasoned assessment of the suitability of that care. And more generally, this is a helpful decision about the approach on intensity of review that you see in these types of cases. The court was getting in Robert Palmer KC sitting as a deputy, got into the weeds somewhat at an interim relief stage. The balance of convenience is often a difficulty in these types of cases at interim relief stage. Nicola spoke to the case I was involved with, where we didn't go for interim relief against the Secretary of State for the Home Department in relation to Section 95 accommodation, but we lodged the claim with an N463 seeking expedition. That meant we got into Imam and Croydon territory rather than balance of convenience territory, which I think if you can wait the 5 weeks that we could wait, because it had been a year-long breach in that case, it has particular disadvantages. The burden is on the local public authority, be it local authority or Home Office, whatever it might be, to establish impossibility, which is a much harder test for them to satisfy than balance of convenience. But granted in part, Merton was ordered to provide overnight care for 20 nights per month, an increase from 8. And the interesting part is what followed. So you'll note this was 2023. This is a 2024 case law update. The 2024 bit comes next slide. And it's broadly helpful, but a bit odd, would be my conclusion on this, which is, okay, the claimant is now 18. There are two rival forms of interim relief that are on the table. Which one is the court preferring? Because the interim relief was made in respect of children-related statutory provisions, and there is no, spoiler alert, the court, Mr. Justice Swift, continued the interim relief that was in place for Section 17 and Section 2, despite the local authority promising to sort of try and match the support, and even though the child was no longer a child. So it's slightly odd. So I'm not going to go through this. I'm conscious of time. I've got 3 minutes to get through another case. So it was common ground that an assessment of the claimant's needs under the 2014 Act was required. It was common ground that some form of interim provision should remain in place. The primary difference between the competing draft orders was claimant's draft premised on continuation of existing draft order. Defendant's draft order replaced it with an undertaking by the local authority to continue to provide care at level set, but not under the same statutory basis. And essentially, it's just, let's continue the status quo without more reasoning to it, which I think is potentially somewhat unsound in terms of legal basis, but helpful as an approach for what's in the best interest of a child who's now a young adult. So I just wanted to flag it for those navigating the practical difficulties of you've got interim relief in place. What do you do when there's a new decision, you're amending, but you want to keep the interim relief in, want to keep a level of support in place? So TS and Hackney, again, this isn't necessarily setting new principles of law, but it is a helpful case. And it's 2023, but it was December 2023, so I feel it's okay. And we didn't include it last year. So what this is about effective assessment by local authority, and it's principally what a rationality review and how effective that can be, how much the court will get into the weeds of it, and actually in these types of cases, you frequently see public authority say, oh, this is impermissible merits review, whereas as a claimant, we're trying to say, look, it's intensive scrutiny in these types of cases because of the profundity of impact and the KM line of authority. And this case really shows a court grappling with what a proper assessment should take into account. I'm not going to go through all 7 points on the slide. You'll get these slides, but it really did not engage. It really tackled and didn't do a surface level sort of, oh, it's rationality is a high standard, it's very hard to get over sort of thing. It did look, okay, this was an obvious thing that they at least needed to consider in their assessment of a disabled child and what need they required. So it was both cumulative but also it's hard to know from the reasoning whether one of these would have been a knockout blow, but the court really went in on the detail in a way that's quite helpful to show what the proper approach is, particularly in the cases where you have defendants saying, look, this is a rationality review rather than merits review. This is what a rationality review looks like in practice in respect of a disabled child. So I think it's a really helpful case to have up your sleeves as a claimant practitioner. Ground beef failed. I'm not going to go into that. There's nothing particularly interesting in that. But essentially, care planning leads to irrationality, is the link up between failures in care planning leads to irrationality, and the typical formulation of ex parte belching. So I very briefly want to give a plug, not least because our colleague is the lead lawyer on this, on sabbatical at the moment, Connor Johnson, has done an absolutely brilliant job putting together a consultation paper. And because the deadline has been extended to the end of the month, the Department for Education has asked the Law Commission to undertake a review of the law on children's social care. As you'll have seen from our presentations, it's quite knotty as an area of law. There's intersecting and quite old statutory provisions, and there is a lack of clarity, which leads to gatekeeping, unfortunately, because lack of clarity tends to benefit a public authority trying to wheedle out of its obligation. It's a really important consultation. You don't need to answer all the questions. If you've got a voice of lived experience, they want to hear from you. If you're a practitioner working on the ground with disabled children, they want to hear from you. We would really encourage you to respond, and so that there is as much evidence before the Commission so that they can make a fully informed proposals going forward. There's a really helpful video that's linked there from Connor and others. Strongly recommend that you watch it, engage if you can. Thank you very much for your time. I'll hand over.
Thank you, Ollie. Alex.
So I've got 4 cases to talk about, but 2 of them are in the same vein, because we've already had one mandatory order case today, and we've got 2 more in the context of special educational needs. And I'm sure there's only so much of commentary on the application of the principles in IMAM that we can all take. So this first case is LB Hampshire, and this is a claim that the defendant local authority was in breach of section 42. It all starts very standard and is in many ways very standard. That the defendant acknowledged that they were in breach, and they did not oppose the making of a declaration, but they did oppose a mandatory order. And so the only dispute between the parties was whether or not a mandatory order should be made. The defendant's position was essentially that it was doing it anyway, and that making a mandatory order would be either wasteful because they would succeed without the need for a mandatory order, in which case, what's the point? Or they would not succeed, but not for reasons that were within their control, because they're trying to engage with third-party contractors, in which case they're going to be unfairly facing contempt proceedings for something that was out of their control. The claimant had an EHCP, had an EHCP since 2020. The present EHCP had been issued following a successful challenge to the FTT. It was meant to provide for an EOTAS package and directed that that package be put in place. Very little was in place by the time of the final hearing. And this had a really significant impact on the claimant. He'd become increasingly anxious, displayed depressive symptoms, had become selectively mute in the mornings, and had also become dysregulated and lashed out at his mother. So it's obviously causing real stress and hardship in the household, on top of all the ordinary hardship and harm that comes to a young person for being out of education. A final hearing was initially listed for the 14th of February 2024, but adjourned after assurances by the defendants that the provision would be secured by the 19th, but it wasn't. And that was the slide that took me the longest to do, because I was trying to center the text, and for some reason it wouldn't. As I said, the defendant said that there was basically no point. They'd engaged in an organization called Fresh Start in Education, but there were no details finalized by the time of the hearing, and there were no alternatives. The judge in the judgment makes a point of saying that the defendant could not say at the hearing essentially what the contingency planning was, and was very critical of what they called drift and delay. An EP had been secured but couldn't begin their responsibilities until the fundamental special educational provision was in place, and a notional personal budget had been agreed but no payments had been made. The parents claimed that it was overly restrictive in the way that it was worded. We've talked about IMAM already today, so I'm not going to labour the point. The key principles here are that the starting point is that the mandatory order should be made because a person is entitled to relief where a breach of a statutory duty is causing them harm. And it's going to be incumbent upon the defendant, of course, to prove that or demonstrate why a mandatory order shouldn't be made. And IMAM sets out the 5 criteria that we've talked about already that aren't on the slide, but I don't think we need them. which is the need for contingency planning in terms of allocation of resources to deal with unexpected expenditure. Second, whether the authority had been on notice of the problem in relation to the non-performance of its duty, but failed to take the opportunity to remedy it in good time. Third, the impact on the individual to whom the duty is owed. Fourth, whether the authority has been taking steps to remedy the situation. And fifth, the need not to cause unfairness to others by prioritising the claimant. So the decision, it's just a bit of a wall of text. I'm not going to go through the whole thing. The claim was allowed and the mandatory order was granted. The court wasn't particularly impressed with the defendant's points. Hope that it was going to be resolved was not enough. The court was sympathetic that the claimant didn't have faith that the defendant was going to get it in place without the court making a mandatory order. It's not an excuse that the defendant relies on external parties. The court said that's almost always going to be the case, which of course it is when complicated packages of special educational provision are being put in place. And so if it was the case that the court couldn't make that order because it might be something legitimately outside of the defendant's control that causes them to breach, then they would never be able to make an order. And what the court said was, well, if you fail and you do breach, then in the course of the contempt proceedings, if they follow, you will be able to justify, and I think the implication being with much more, to a much greater level of satisfaction, that you've taken the necessary steps in order to remedy the breach to the level that you were possibly able to do. And finally, there was a point which I think is an interesting one, because I've certainly seen it come up in the last year, and I don't think I'm the only one, about whether or not it's relevant that a future EHCP might be put in place. What the defendant said was, well, if a mandatory order to put the existing package of special education provision was made, then we wouldn't be at liberty to review the EHCP in the event that the package becomes impracticable. And the court basically said, well, we're not concerned with a hypothetical future EHCP. The obligation in the breach relates to the document that the court had in front of it, which is what it was concerned with. This one's really similar, except the defendants didn't accept there was a breach. And they said that if there was a breach, then it was minor or technical. The claimant had attended a special school, had very complex and challenging needs. As you can see there, that the ratio at times that was needed in order to provide education was at 5 to 1 when he was dysregulated. The school was saying that he would need 3 to 1. But that was refused. And eventually the special school place ended in July 2024. The local authority said that was a natural transition point and that he could no longer be supported in that school or any school, and said they put in place an EOTAS package, which would be delivered at a residential school place. They said that they couldn't put that package in place until the residential place was secured, because it was incumbent upon there being a residential place in order for the SEP to be secured. And therefore there was a break, and the claim essentially concerns what happened during that break between the two placements, and therefore whether or not they could put the special educational needs provision in place, because they couldn't do it at home. There were specific circumstances that meant it was impractical to put the provision in place at the claimant's home, and the defendant made no criticism of those reasons. So it was essentially an agreement that they couldn't put it in place at their home. So the claimant said that to secure the provision does mean that it has to be actually available, has to be capable of being taken advantage of. And the claimant criticised the defendant for not accepting that there was a breach, which the court eventually did as well. The defendant said it was doing the only thing it can realistically do to secure the provision, and it relied on the unusual and specific facts of the case to say that there's only a limited number of options by which they might have been or might be able to secure the provision following the termination of the school place. None of those options are viable or could have proved capable of resulting in the SEP being provided to the claimant any faster than the approach which the council is already undertaking. Now, it's interesting that that's a very similar position to what the defendant in L said, except they've differed on whether or not they actually accept there's a breach. The court found that where there was a breach, it was a binary yes-no question. It's not about it being minor or technical. And in discussing the time allowed to bring the provision on time, there's obviously the 5-week period from date of an FTT decision. They criticised the fact that there had been delays and failure. And whilst they might currently be doing the things they can do to bring the provision online, that hadn't always been the case. They hadn't acted expeditiously when they knew that the placement at UGS was going to break down, which was back in April. And so it wasn't necessarily the case that they should have only just started acting once the place actually came to an end, or when a new HCP was issued, which was in August. Essentially, they had adequate and good notice. Going to kind of just really skip over this because we're short on time and I want to give Abby enough time. In very brief, the order was again granted, and the court said the impetus and which mandatory order will be provided is necessary in this case where there is a vulnerable claimant suffering profound consequences of the absence of provision since the beginning of September 2024 term. And again, this is a case where the court did accept that there was steps being taken and that the provision, or at least a good amount of the provision is likely to come online. So I think it shows when we have these cases where there's endless correspondence back and forth about whether or not the provision is going to happen, and the defendant says it's coming. There's no point in issuing proceedings because we're going to get it online very soon. Actually, the court is going to apply quite fierce scrutiny, as it did in both these two cases, to whether or not that's true and what steps have actually been taken. So this is the first of two upper tribunal cases I'm going to talk about. This one is about a decision to cease to maintain an EHCP for a 17-year-old. An appellant, again, of course, with very complex needs, needed intensive support. And essentially what the local authority said was that the amount of support he was getting was very significant. The amount of progress he was making with that educational support was very small. And so it was no longer necessary to maintain an EHC plan. And what he should do is transition into adult social care where they can support him to make the same progress. And that was a position that the FTT agreed with. And so the young person appealed. Permission was granted to appeal on two grounds. The first concerned whether or not the correct legal test had been applied. And spoiler alert, it wasn't. Summarizing, the UT said the FTT decision was based on their conclusion that the appellant was not ever going to achieve his current learning outcomes. He was not going to achieve a specific set of skills, those that would enable him to acquire independence and go to his employability. And he was not going to make a certain level of progress as he did not have the necessary significant level of learning potential. The second ground was about the adequacy of reasons, but they are related. So paragraph 45, the crux of the FTT's reasoning is that because a significant amount of special educational provision had been needed to achieve what they considered amounted to a small amount of progress, an EHC plan was no longer necessary. The conclusion that the amount of learning must reach a certain degree in proportion to the amount of provision made for an EHC plan to be necessary is not supported by the wording of section 45, although the potential for learning may be a relevant factor as to the question of whether an EHC plan is still necessary. A particular level of learning potential is not an essential prerequisite. At its heart, the UT said that this is a test of necessity, which is just to adopt the statutory language, and that there is no balance to be made between potential and progress. Regarding whether the appellant could have met his outcomes with social care support, this goes to the reasons, the adequacy of the reasons, and the upper tribunal said that the FTT's reasons did not address the question of what provision was necessary to enable the appellant to develop independent skills. The FTT's reasons did not address whether that provision fell within the definition of special educational provision as set out in section 21. It is difficult to see how the FTT could have concluded that the necessary provision could be, it's difficult to see how the FTT could conclude that the necessary provision could be made by social care and without an EHC plan, without first addressing the question of what provision was necessary. It's just a stage that the FTT appears to have skipped altogether. And the appeal was allowed. This is MM. This concerns litigation capacity within the SEN proceedings. It's an unusual claim or appeal because it's one in which Mum assisted the appellant, but was not the appointed alternative person. And it was then a ground of appeal that the FTT had failed to recognise or consider whether or not the appellant had capacity. And the appeal was granted on the basis that the FTT failed to take steps. But the interesting factors are what the guidance the UT gave to the FTT in what it should do in those circumstances. So in this case, C had a diagnosis of autism spectrum condition and global development delay, amongst other things. It was on that basis alone that the tribunal said that essentially alarm bells should have rung out, that this was a person, an appellant without an appointed alternative person. I said, I'm satisfied that this was a case where the fact that C probably did not have capacity to conduct the appeal shouted out from the papers, and the tribunal ought to have recognised that this was an issue just from the reading of the bundle and even before the first day of the hearing, and it wasn't sufficient. They should wait upon either of the parties' representatives, no matter how experienced they might be, to bring to the tribunal's attention. I'm going to skip over the rest. So that was point one, was the point about the capacity. Point two is about whether or not the appointed person, who you'll see was appointed, it's an alternative person for the upper tribunal, whether or not they were acting in their best interests anyway. And this goes to materiality, because what the tribunal said was, just because the person doesn't have capacity doesn't necessarily mean that it would be material. But of course, an appointed person has an obligation to act in that person in the litigant's best interests. And the upper tribunal essentially concluded that they weren't acting in their best interests, and gave guidance as to what the tribunal could have done in those circumstances, which include, for example, stopping short of dismissing them as the appropriate person, but even just as simple as giving guidance as to what they have to do, what their obligations are, and using their other general case management powers in order to make sure that that effect is given to the obligation to act in that person's best interests. The upper tribunal said it would be to take a sledgehammer to crack a nut in order to simply dismiss the person as the appointed appropriate person. Perfect. Thank you very much, everyone, for your time.
Thank you so much, Alex. Abby,
Thank you.
our last part.
I'll try to be quick. So I'm going to cover 3 school exclusions cases from the admin court in the last year. They are LM, which is a straightforward school exclusion JR, RWU, which concerns the operation of the Article 4 protection duty in exclusions cases, and TTT, which is primarily a freedom of religion indirect discrimination case, but also considers procedural issues in school exclusions. So starting with LM, the facts of this case were that there was a permanent exclusion for significant and persistent breaches of the school's behaviour policy, which involved sexual misconduct towards other pupils. The governors upheld the decision, the IRP quashed and directed reconsideration, and the reconstituted GDC upheld the exclusion. So the claimant in the JR sought a quashing order and reinstatement, and there were 5 grounds of challenge. They were predominantly based on irrationality and unreasonableness, and there was 1 ground of procedural unfairness in relation to the governor's decision. None of these grounds succeeded. I'll just go over some notable points, although I don't think there's anything particularly surprising in there. The first is about the scope of reconsideration. So the court decided that the governors were entitled to start with the head teacher's reasons for the permanent exclusion on reconsideration, rather than starting with a blank sheet of paper, as the defendant put it. This is consistent with what Lord Justice Sedley said in Dunraven School, and that the governors were also not required to accept every criticism of the IRP, but they just needed to ensure that they were given conscientious reconsideration, which again is in line with paragraph 259 of the school exclusions guidance. On risk assessments in this case, so the claimant argued that the governors should have obtained a risk assessment for themselves rather than relying on the head teacher's informal assessment. And it was held that the risk assessment in cases of alleged sexual violence, as set out in the Keeping Children Safe in Education guidance, is not a precondition for a permanent exclusion. And in this case, the head teacher's professional judgment sufficed. That's at paragraph 36. The issue of the right to be heard was also considered. So it was found that there was no procedural unfairness by not allowing the claimant to make oral representations before the reconstituted governor's decision, the governor's disciplinary committee. And that was because the family had instructed counsel, who had cross-examined the head teacher extensively at the original governor's hearing, and then also made written submissions to the reconvened hearing. So, as I said, none of those grounds were successful. And from a claimant practitioner's perspective, it's quite hard to find anything particularly helpful in this decision. It could be interpreted, I think, as a fairly deferential decision towards the reconvened governor's treatment of the head teacher's actions. But I also think these cases are intensely fact sensitive, and the judge's decision in the case is very closely tied to these particular facts. There were no protected characteristics or SEN issues raised in this case, as there so often are in other school exclusions cases. And so I don't think it's necessarily a sign that school exclusions cases are now harder to win through JRs in general. Moving on then to the next slide. So this is RWU. This is a case in which Nicola, Ollie and Harry Harris acted for the claimant. It was handed down in November last year. And just briefly, the facts were that the claimant was excluded for persistent breaches of the school's behaviour policy. There were many indicators of child criminal exploitation at play here. So, for example, the claimant was doing really well at school before he started year 10, where there was a rapid deterioration in his behaviour, and there were 5 suspensions in his first term. He came to school under the influence of drugs. He was finding it difficult to stay awake at school. There was the involvement of police. He was staying out until 4 a.m. on some nights. There were visits to A&E for suspected knife wounds, and there was a deterioration of his behaviour while his mother had gone abroad. So that's obviously a protective factor in his life that wasn't there. The permanent exclusion happened after the claimant came to school with drugs on him, which he would have been suspended for, but because this was the 6th time, the permanent exclusion could be considered under the school's behaviour policy. The IRP, or the governors, upheld the exclusion. The IRP quashed on reasonableness grounds and directed reconsideration. And among other reasons, the IRP found that there was not enough curiosity around the child's circumstances when considering the risk of CCE. So the reconstituted governors panel upheld the exclusion, and this was the decision that was judicially reviewed. So the judgment was given by Mr. Justice Fordham, and I just want to highlight 3 areas of his decision. Firstly, is very briefly on the intensity of review in these cases. So in answer to the question of how the court will approach the governor's reconsideration, or how the court should approach the governor's reconsideration decision letter, I think this is a paragraph that will be cited in future cases, probably by both sides. But I thought it was helpful to include here. If you could just go to the next slide, please. Yeah, so it's there, and Mr. Justice Fordham stated that these decisions should be approached with close scrutiny, with reduced benevolence, and with a heightened reluctance to allow any resort to retro reasons, but always taking a straightforward, not legalistic, nitpicking or technical approach to reasons and the ways they've been expressed. And by retro reasons, he was referring to witness statement evidence which had been put forward as elucidatory of a reasoned decision. So in this case, the chair of the governors provided a statement after the decision, and you can see in the decision that Mr. Justice Fordham is very careful to state that he isn't relying on those statements in reaching the conclusions that he does. The second issue is in regards to fresh evidence and hindsight. So both parties sought to rely on fresh evidence in this case in their own ways. For the claimant, I've already gone over the retro reasons, but for the claimant, some of the evidence related to incidents that had happened after the permanent exclusion, and some of them after the reconsideration hearing as well. The evidence was relied on basically just to say, look what happened to him in the end. There was clearly a risk of CCE the whole time, and this was evident all along. So, for example, there was evidence of hospital visits for suspected knife wounds, conviction for knife possession, and an arrest for aggravated burglary, which then led the local authority to make an NRM referral, and a reasonable grounds decision was then made. Mr. Justice Fordham set out that fresh evidence can, of course, be relevant when looking at what information ought to have been known by a decision maker, but that the legal relevance will depend on the nature of the legal issues. And he was at pains to state multiple times throughout the decision that the judge's assessment of the governor's decision cannot be based on hindsight. And he addresses each piece of fresh evidence and why he thought that it wasn't of direct legal relevance at paragraphs 33, 35, 37, and 55. So the real key issue in this appeal was around the permanent exclusion decision and how that interacts with the Article 4 protection duty under the European Convention. So I've included what that duty is. So by virtue of Section 6 of the Human Rights Act, I won't read out the whole thing. many of you will be familiar with it, and we're very short on time. What the duty actually is there on the slide. The issue before the court was whether the governors, when they reconsidered the decision, failed to construe the permanent exclusion test compatibly with the Article 4 positive obligation, because there were clear indicators that the claimant was at risk of harm from CCE. And there were 3 steps that were identified as being necessary to tackle this question. The first was the relevance of the Article 4 positive obligation to the permanent exclusion decision in general. And it was the claimant's case that while the school is not a first responder under the NRM, like the local authority or the police, it is a relevant public authority under Section 6 of the Human Rights Act. So the protection duty may arise through that, in that way. And Mr. Justice Fordham agreed that, and this is at paragraph 61, that the same circumstances which would trigger Article 4 protection duty would be a relevant consideration to which be regarded when considering the permanent exclusion. The second step was looking at how to determine when the duty arose. I think this is also a really important point, because he was clear that it is for the court to look objectively at the trigger test under Article 4, again emphasising that it's not an exercise in hindsight, but it's for the court to look at this test. And then finally, looking at the question of whether the circumstances at the time, just going back still, thanks, were such that the positive protection duty arose in this case. The claimant said yes, because by the time of the PECs, and certainly by the time of the reconvened governor's decision making panel, it was clear that there was a risk of CCE, and that's at paragraphs 63 to 4, for a full outline of all of the things that were known at the time. However, Mr. Justice Fordham unfortunately didn't agree and held that the circumstances that were known at the time did not trigger the duty. And his reasons were, for example, the Academy was alive to the issue of CCE. They'd flagged to the police on the day of the permanent exclusion when the claimant brought drugs to school. It was never argued before the governors that the Article 4 duty was engaged or owed. There was a MASH referral, and the school had liaised with the claimant social worker. An interesting argument also that was relied on was that neither the LA nor the police, who were both first responders, considered that the positive obligation threshold was crossed until the NRM referral was made some 8 months later after the permanent exclusion. And I think this places quite a lot of trust in the local authority and police to get it right. And they are, of course, fallible institutions, and they might have missed the signs. And so I think it's quite unfair for that to have been a reason relied on by the court in this instance. But anyway, I think the key takeaway for the time being is that if CCE or county lines are an issue in one of your cases at the moment, if you're representing a pupil, is that it's important to raise the Article 4 duty at every stage of the appeals process, in light of what was said about the fact that this hadn't been raised before the governor's body. And in any case, the decision has been appealed and is due to be heard, I'm told, at the end of January as a rolled up hearing in the Court of Appeal. Black Equity Organisation have also been granted permission as an intervener, and Duran Seddon KC and Nadia Omara are acting for them. So that's one to look out for. So I will very quickly, I know we're over time. Many people will be familiar with the case of TTT on the next slide. It received a lot of publicity. It's mainly a case concerning freedom of religion and indirect discrimination. The grounds in relation to those points actually weren't successful. So it concerned a prayer ban at the school, which impacted Muslim pupils who wished to perform a prayer at a particular time. It's a school which had a notoriously strict disciplinary policy. What the aspect of the judgment that received slightly less attention, but which is helpful in the school exclusions context, I think, is how the school dealt with the fact that the claimant in this case had received 2 fixed-term exclusions. There were, and she was successful in relation to the second one. Just very briefly, the reason why she was successful in relation to the second one, but not the first one, is because in the first one, there essentially weren't any disputed facts. And so it was held that the school was justified in not seeking her views. But in relation to the second fixed term exclusion, there were lots of different accounts of what had actually been said by the claimant. And 6 other pupils were interviewed, but the claimant herself wasn't interviewed. And so this was found to be quite clearly a breach of the school exclusions guidance, the school's own exclusions policy, and the school's duty to act fairly. So overall, I'd say that ruling, that very small part of quite a long judgment, is helpful when you're looking at school exclusions cases, and there's been a failure to properly obtain the pupils' views before the decision to permanently exclude has been made, as I've seen many times, especially where there are significant factual disputes. And just the final thing, that was a very quick overview. I was going to go into it in a bit more detail, but I would encourage you to read that part of the decision in particular. And then just finally, is Coram have brought a test case arguing that exceptional case funding must be available in all IRP appeals, where there's an allegation that the permanent exclusion is discriminatory and engages human rights. This will be a really interesting decision. Stephanie Harrison KC and Ollie acted for Coram, and Grace Brown and Nadia O'Mara for the intervener Mind. So that's eagerly awaited. And that is everything from me. Thank you very much.
Thank you so much, Abby. And thank you to all our brilliant speakers. We have gone over, and I've seen that we haven't had any questions in our Q&A box other than one which Ollie has answered. I'm going to wrap up this webinar. Thank you all very much for joining. We very much appreciate all feedback of whatever kind, ideally constructive. So if you're watching online, a feedback form will pop up when the Zoom ends, and please do fill that in if you're able to. We will send through a link to the recording with the slides. And for those of you who are able to attend tomorrow, we have another event on climate change, immigration protection and human rights claims. And that is a hybrid event. It's booked up in person, but we have online places still available. So with that, thank you all again, and I will now close this webinar. Thank you, everyone.